All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 2178. In re the estate of Poe from El Paso County and the 8th Court of Appeals District. Then 2179, in re the Poe Trust, also from El Paso County and the 8th Court of Appeals District. And finally 21727, Maxim Crane Works versus Zurich American Insurance, certified question from the United States Court of Appeals for the Fifth Circuit. The court has allotted 20 minutes for each side in each of the cases, and we'll take a brief recess between the cases, completing them before lunch. The arguments are being webcast live this morning and will be available in the archives later. We'll hear argument in 2178.
May it please the court. Mr. Jefferson and Mr. Hood will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Jefferson will open with the first 10 minutes and will present the rebuttal.
Chief Justice Heck, and may it please the court, I would like to make two principal arguments. First, this case gives the court an opportunity to reaffirm Ritchie, that a corporate director's duty is exclusively to the corporation. And second, that the safe harbor defense in section 21.418 was improperly submitted, so improperly submitted that a new trial is required. And these 2 points are related. Dick Poe created PMI to centralize control of a pretty vast business empire. And he made his son Richard the sole shareholder, consistent with his estate plans at the time. But toward the end of his life, Dick was worried that Richard would not protect his other son, Troy, and Dick became concerned about Richard's management capabilities. So he changed his estate plans to remove Richard from control. And this included, and that's at the heart of this case, a share issuance that returned control of PMI to Dick. Richard challenged that share issuance, and that triggered Dick's affirmative defense. This was an affirmative defense, and that's what the trial should have been all about. An interested director, like Dick, was entitled to issue shares to himself so long as the transaction was fair to the corporation. And if the transaction is fair to the corporation, no person, including Richard, has a cause of action to complain about it. If you look at 21.418E, that point is made, no cause of action. Under the safe harbor provision, the judge should have asked the jury one simple question: was the share issuance fair to PMI on May 1st, 2015, which is the date Dick authorized the transaction? And yet the bulk of the trial and almost the entire jury charge was not about Dick's affirmative defense, but rather a theory that Dick owed Richard a personal duty. And this is why I think Richard hijacked Dick's affirmative defense to include the notion that Richard was, quote, entitled to vote on the share issuance, which was patently not true. If you look at tab 2 has the court's charge, and there you will find surplus instructions from beginning to end and immaterial questions designed to convince the jury that this case concerns Dick's duty to Richard rather than Dick's exclusive duty to the corporation. And that brings me to Ritchie. In
Do we
Rich,
need to reach that issue if we agree with the Court of Appeals that there was sufficient evidence and that there was no harmful error in the charge on question 4?
I think you have to reach that evidence for, to that issue for two different reasons. First and most fundamentally, if we are correct, that question 4 must be disregarded because it presented a question of law to a jury rather than a question of fact. If you agree with that, then the judgment could be affirmed on the alternative basis of the informal duty.
So why shouldn't we address that issue first?
You can address the issues in whichever order you want. I think the most important to the law here is the informal duty. The idea that
But if we agree with the Court of Appeals that question 4 was not harmfully submitted and that there was sufficient evidence to uphold the answer, then we would not reach the Ritchie issue, correct?
well, I think if you agree, if you agree with us that question 4 was wrongly submitted, it wasn't even in the case because it was a question of law, then the alternative basis would be the informal duty to uphold a judgment. You would reach that.
Well,
And then-
why don't we talk about question 4 then? I take it, I understand your point that it submits a question of law, and certainly I think the form of the question could have been phrased better, but one of the things I'm wondering is why is the way it was submitted harmful error in terms, it does say, was the transaction void, but valid and is it valid and enforceable? But then it defines that in terms of the factual question that was being submitted to the jury, which seems unlike the Fredu case which we had from last term, where there was a role for the court to balance the factors, and that was a legal question, and we said, that's something that should not be submitted to the jury. In the way this question was submitted, what legal issue is being taken away from the judge and given to the jury?
Well, we would say just in the way the question is asked itself. And the question is the share issuance valid and enforceable under the Texas Business Organization Code? That's a very odd way to present it. But let's say that the question itself was fine, and it doesn't present a question that this court has to worry about. If you look at the instructions, this is our defense, remember. This is an affirmative defense, and usually, people who are used to trial say, counsel, you're going to put on your own case, plaintiffs or defendants. And so our defense was not 1A, that the board of directors in good faith authorizes share issuance approved by a majority of the disinterested directors. There was only one director, and it was an interested director, and that was Dick. So that was out of the case from the very beginning. It's not B, that the shareholders entitled to vote on the share issuance was specifically approved in good faith by a vote of the shareholders, because no shareholder was entitled to vote whatsoever, including Richard. It wasn't in the bylaws. There was no shareholder agreement that said that. So the only question was whether the share issuance was fair to PMI when authorized. That should have been what was submitted. And the reason
I understand that they dispute whether 1B should have been in there or not based on how the agreement was interpreted, but how is it harmful to your client to have more bases submitted than fewer if any one of them is sufficient to get the answer that you need?
Because the whole trial was centered on Richard's theory that Dick owed him a duty, and B, in that case, was part of that theory. So they took over our defense. They made sure, Richard made sure, that there was an instruction that told the jury that Dick owed a duty to give notice to Richard before the share issuance was given. And the reason I said that these two were related is because that followed up on the entire informal duty theory. That's why the whole case was not about, so far, Your Honor, we've been talking about these duties that Richard apparently thinks that Dick owed to him, and we still haven't gotten to the real issue in the case.
Are you saying that because of confusion, that was the problem?
Yes, confusion, evidence, argument. If you look at the very first page of Richard's closing argument, It talks about his duty, Dick's duty, to have notified him of the share issuance so that Richard could have intervened. That there was no duty. And the only and the sole question was the valuation of was it fair to PMI? And
But
Justice Busby, I just want to make sure I answer one question for you on the informal duty. Mr. Hood is going to explain to you that whatever you do with respect to the case that we're presenting, that Dick is presenting, and the trustees, the informal duty still exists in the case. So the court is going to have to reach it. The court is going to have to reach Richie. And
So on that issue, why shouldn't the law recognize both duties but prioritize the formal over the informal so that Dick would have a duty to act in the best interest of the corporation, and so long as he is doing that, would also have a duty to act in the best interest of his son, and would be excused from the latter only if acting in the son's best interest would be harmful to the corporation? Why shouldn't the law, because the law certainly, separate and apart from this circumstance where they overlap, the law recognizes the value of both duties. And instead of throwing out one in favor of the other, it seems to me there could be a workable structure where both would exist but be prioritized.
Your Honor, I think your decision in Ritchie looked at the potential for conflicts if you were to recognize both. And that's why the court centered on the idea of exclusivity, that the director's obligation is exclusively and should be thinking only about the interests of the corporation, because otherwise the director's loyalty is divided in ways that are incompatible with the proper governance structure in Texas. And I'll say one more thing. The common law used to say, yes, this fiduciary duty exists and you should be thinking about that. The statute, in the statute, the legislature said, no, there are circumstances in which an interested party can be favorable to the corporation. And we're going to give a safe harbor in that event as long as the transaction is fair. I see that my time is up, and I will cede the rest of the opening argument to Mr. Hood.
Any other questions? Thank you, Mr. Jefferson.
Thank you.
Mr. Hood, we'll hear from you.
Mr. Chief Justice, and may it please the court. Justice Busby, in answer to your question, the informal duty is unquestionably alive, and that's because my client, Paul Surgeon, is going back for another trial on Richard's conspiracy claim. That conspiracy claim had two distinct aspects. One, it was asserted derivatively on behalf of PMI based upon the unfairness of the transaction in terms of Dick buying shares that Richard claimed he paid a lesser price for. But he also claimed that Mr. Surgeon conspired with Dick to breach the individual duty to Richard. The Court of Appeals, in its disposition of the case, didn't address the latter. It simply said, whatever doubts we have about whether Mr. Surgeon recognized such a duty existed, it's clear that he knew that Dick owed a fiduciary duty to PMI, and so we're going to send it back on that theory. The problem is that the judgment, which is what this court reviews, not the opinion, but the judgment, reverses outright the directed verdict. It frees Richard to assert on remand both the derivative claim on behalf of PMI as well as his individual claim. That is a clear violation of Rule 47.1. Rule 47.1 required the Court of Appeals to address every issue necessary to the disposition of the case. And because there were two aspects, two independent bases for the conspiracy claim, both had to be addressed. The Court of Appeals' disposition of the case puts Mr. Surgeon in an unfair position on remand. He is essentially starting a 100-yard dash, 50 yards behind Richard. And the reason for that is that two issues critical to the conspiracy claim, breach of fiduciary duty to PMI and breach of fiduciary duty to Richard have already been decided against him. And they have been decided against him even though he challenged the existence of that relationship. And the Court of Appeals said, we're not going to address it. And even though the charge did not ask the central question, was this transaction fair to Poe Management, Inc.? As Mr. Jefferson said, that's the only issue in the case that should have been submitted. Instead, Richard, in effect, hijacked our affirmative defense. And he said, well, you've got to put in all of this about the shareholders voting on the transaction, even though there was nothing in PMI's organic documents that gave Richard any right to vote on the transaction or required notice to him.
But Mr. Hood, the jury could have answered that question in your favor if they concluded that the transaction was fair, right?
They could have, but the problem, Justice Busby, is that it was so clouded by other irrelevant considerations.
Those seem to be independent to me in the way it was submitted.
It is phrased in the disjunctive or. I grant you that, just as the statute says. But the problem is, and if you look at the closing arguments of counsel, particularly Richard's argument, he does two things that in essence, in our view, show the harmfulness of the error that was created. The first is, in response to your question, he suggests that he had a right to vote on the transaction and that he had a right to notice of the transaction. He had no such right. The second is, and this is another reason why you have to address the existence of this personal duty owed to Richard, is that he conflated the existence of fairness to him with fairness to PMI. That was a consistent theme that he argued in closing to the jury.
Shouldn't we assume that the jury followed their instructions, though?
Well, even if you assume that, the manner in which question 4 was phrased, and given that it was submitted following the independent theory based upon breach of an individual duty to Richard, it's clear that the jury was influenced in their answer to question 4 by the submission of questions 1, 2, and 3 dealing with the individual duty.
And what's our best case that you would point us to that's reversed on that basis?
I don't know that I've ever seen any case like this where you have a clearly, in our view, a clearly invalid theory submitted in which the plaintiff conflates that with a valid theory. I looked in vain and I could not find a charge case to that effect. So this case is, the proverbial, first case of first impression.
Go ahead.
What if we agree with you about the fact that the focus of the trial should have been the fairness rather than the notice to Richard? Isn't price one of the principal factors that plays into fairness as to PMI? And if it is, how can it be that the jury should not have considered evidence after May 1st when it wasn't until after May 1st that the price was determined?
Let me go ahead and go back and unbundle that. First, the difference between May 1 and May 6 in terms of fair market value, I don't know that there really is anything there. Price is certainly a consideration. There is absolutely no question about that. Is it the only consideration? Clearly it is not. As the witnesses testified, and as I think the law would show, fairness is a concept that extends beyond fair market value. Fairness is overall in terms of the management of the corporation. And if you look at the Business Organizations Code, for example, in other areas, it indicates that corporate directors may consider things beyond just the monetary value of a particular transaction. So yes, price is important, but price is not the only consideration. As to your second question, why should the jury be precluded from looking at events after May 1? The legislature made that decision in effect for the court by saying, you look at the fairness of the transaction when authorized. It was authorized by Dick on May 1. There's no dispute about that. The real issue is what should have been considered after that, if anything. And our position on that is really nothing, particularly the actions taken by Gulf States Toyota to attempt to terminate the dealership. The reason for that is that wasn't on the table on May 1 when Dick authorized the transaction. Indeed, it wasn't on the table on May 6th when he wrote the check for the shares that he purchased. And so in that sense, Justice Huddle, price is important, but events occurring after the authorization really don't come into play, because the price of the shares, yes, it was determined after May 1, but it's not as though Dick on May 1 would have known that, well, I should pay $5 million as opposed to $3.2 million for the shares. I hope that answers your question. But clearly, when you get into things that occur months after his death, months after the transaction has been authorized by Dick as the board, that's something that the legislature essentially cut off, because it says fair to the corporation at the time it was authorized.
Your time has expired, Mr. Hood. Are there any other questions? Thank you, Mr. Hood.
Thank you, Your Honor.
We'll hear from the respondent.
May it please the court, Mr. Millimet will present argument for the respondent.
May it please the court, it's an honor to be here today. I was lead trial counsel for Richard Poe. I argued for him in front of the Court of Appeals, and I'm here today to argue again in front of this honorable court for why the jury verdict should be respected and why the judgment of the trial court granting declaratory relief to Richard Poe should be upheld. Richard Poe has been without control of his own company for 6.5 years, and that's untenable. I submit to this court. The issue in this court and below was not solely the issue of whether or not a personal duty or an informal fiduciary duty was owed to Richard Poe, contrary to what you heard in petitioner's argument. The focus of the case, if you look at closing, opening, all the evidence, it was about fairness. They wanted this case to be about fairness. And the reason why question 4 alone should not have been submitted is because fairness only goes to whether or not there was an answer or a safe harbor to a breach of a duty of loyalty, a formal fiduciary duty of loyalty. It does not address the formal fiduciary duty of due care. And yet they got the trial court to admit or to remove our question 1, which was, did Dick breach his formal fiduciary duties? In fact, in the Court of Appeals, they argued that the judgment should be, the trial court's judgment should be reversed because we didn't prove there was a breach of formal fiduciary duties, even though they asked the court and got the court, the trial court, to remove our question 1. And if you look at Exhibit 1 in their exhibit book, they give you their question. Page 1564 of the clerk's record dated May 16th, 2018. They did not give you the second page in that exhibit book, the second page they submitted to the trial court that they asked. And that was requested instruction number 1. This instruction is to be given in connection with special issue number 1, their requested question. In answering whether share issuance was fair to Poe Management, Inc., you should consider all circumstances surrounding the transaction. That was their request. The trial court granted that request. And as such, to your question and to your point...
Isn't there a difference between instructing the jury to consider all surrounding circumstances with respect to the fact question of the fairness, as opposed to instructing them to consider all surrounding circumstances with respect to the legal question of the validity and enforceability of the validity and enforceability, which is what the question ended up asking?
I agree with you, Your Honor, that all circumstances go to the factual issues involved and not to a legal issue.
But the question directs them to consider all circumstances with respect to the legal question.
Well, we agree with the Court of Appeals that the question did not ask a pure question of law, that it asked, if you look at the entirety of the question, it asked for factual determination. And importantly, the jury, to your question, to your point earlier, was not deciding a legal issue. The legal issue ultimately was whether declaratory relief was going to be granted to my client, which is what the trial judge decided based on the jury verdict. The jury didn't take a legal issue away from the judge. All it decided was the factual issue of whether or not, under the circumstances, the transaction was fair to the company. And the jury
Does
said it did not.
Does the fact that this was a closely held family business come into play, and if so, how?
I think it comes into play, Your Honor, with respect to the informal fiduciary duty side of things. It comes into play under fairness as well, because as the Court of Appeals noted, properly and so in our view, the sole shareholder was not given notice of the transaction. And the testimony of the trial was very clear why that didn't occur. It did not occur because they did not want Richard to upset that apple cart. If Richard had found out about what was going on, he had the ability to call a special shareholders meeting and in half a day issue a one-page ruling of the court of the company that says, I am removing my father as sole director of this company. And if he had done that, then we would not be here today because there would not be a share issuance. The evidence was undisputed at the trial that the reason why notice was not given to Richard, the sole shareholder, was because they didn't want him to stop what they were trying to do behind his back. And that has to be a circumstance the jury is allowed to consider in connection with whether it is fair to the company, which is owned by one person. And so, to that, Your Honor, I think there's multiple reasons why notice was fair. There's multiple reasons why Richard and closely held corporation is relevant to the questions that were presented to the jury at the trial.
I don't understand why the transaction couldn't be fair or unfair to the corporation and fair or unfair to the shareholder. They just wouldn't have anything to do with each other necessarily.
I think that's right. I think that goes back to the point of fairness is aimed at only one of the four corporate fiduciary duties that exist under the law of Texas.
If Toyota weren't involved, would this be unfair to the corporation?
It would be unfair because in addition to Toyota, PMI was also the general partner for the dealerships, for the limited partnerships that own the Chrysler dealership and also the Dodge dealership. And the undisputed evidence submitted at trial was that after the share issuance, after people who had no idea what they were doing running a car dealership, and that was all admitted, they had no qualifications, the performance at both Chrysler and Dodge went down, and went down fairly significantly. And so in addition to Toyota, there was substantial evidence, which was undisputed, that indicated that there was harm to PMI because PMI was a general partner of those dealerships that owned the Chrysler dealership and the Dodge dealership. And so to your point, Your Honor, there is multiple evidence in the record that goes to why it was unfair to the company beyond just the Toyota evidence.
I want to ask you about the informal duty and in the context of a formal duty. If you were a director and you wanted to say, I would like to live the rest of my life no longer owing this duty, would simply resign as a director. What about in the context of an informal fiduciary duty? How do you get rid of it? Why didn't Dick end it when he said, for example, we're going to negotiate this potential sale of an asset at arm's length with lawyers and then call the deal off? If that doesn't end the duty, if it exists, what does?
Well, Your Honor, first of all, I'd say...
Is it perpetual?
No, I don't think it's perpetual. In fact, they got the trial court to issue question 2 to the jury, which was, did the special relationship of trust and confidence terminate on or before May 1st, 2015? So the jury was specifically asked that question. They were presented with all the evidence, and they decided that it did not terminate. So we have a very good jury verdict here. And by the way...
How would you terminate it?
It would be terminated in a way that you could give notice to Richard and say, things have changed, and I've issued the share issuance, and I'm taking back power through gaining majority control. It could be terminated by Dick actually talking to his son and saying, this doesn't work for me anymore. There are lots of the ways that it could be terminated, with, I think respectfully, that were not done in this instance. In fact, the evidence that you're referring to with respect to the potential sale of the Chrysler and Dodge dealerships, the evidence was disputed, but our evidence indicated that it was a collaborative arrangement between Dick and Richard to try and negotiate a price that was fair, but also would withstand kind of tax scrutiny by the IRS. And it was done in a way, even though on face value it appears to be at arm's length, it was done within the rubric of that confidential relationship because it was being sold for as low a value as possible to withstand scrutiny and pass on my assets that had been in the family since his great-grandfather, Richard's great-grandfather, Dick's grandfather, and passed those on to keep them all within the Poe family.
Did the nomination of Dick as the sole director for the management of the company by Richard disavow any other duty to Richard by ceding basically control over management of the company? And why wouldn't that nomination formally affix the duty that Dick had, to the extent that there was any confusion about where that duty lie?
If I understand Your Honor's question, I believe that the actual evidence of Richard putting Dick in place of his company is demonstrative of the fact that there was this confidential relationship. Dick had no ownership interest whatsoever in the Dick Poe Toyota dealership. We put that in our briefs. That was undisputed, and yet Richard, on an annual basis, was giving full control to his father, Dick, to manage the business for his behalf.
Without restriction.
Without restrictions, he let him do it.
Without requirements of notice or restrictions on issuance of stock or any of the kinds of restrictions that might be accorded in an agreement, nominating agreement for a director.
I would submit that the absence of any kind of shareholder agreement here, as Mr. Sergeant, the lawyer, testified at trial in volume 12 to page 183, he admitted there was no need for a shareholder agreement in this case because it was a single shareholder company. It was created for estate planning purposes, and there was no reason for Richard not to trust his father, because the plan had always been that Richard was going to acquire ownership and operational control over the family businesses after Dick was no longer interested in performing that duty, or when he was moved on, whether it was retirement or death. And so I would submit that the evidence here demonstrates the reason why the jury properly found an informal fiduciary duty here. That is because Richard trusted his father, and this is the way that the family businesses were always arranged, with the understanding this is why we're doing this. And contrary to a point that Petitioner's Counsel made, PMI was not originally created to manage the entirety of all the Poe family businesses. It was only originally created in connection with ownership of land that was bought in West El Paso. Subsequently, PMI takes on much more significance because all the other family businesses are then added to the PMI rubric, where PMI is added as the general partner. That occurs years down the road. Initially, when PMI was created, it was undisputed at trial that PMI was created as an estate planning device for Richard by his father, Dick. That is what PMI was done for. And that was the similar structure that existed with the other companies that were eventually merged into PMI, and PMI eventually became the general partner of the businesses down the road. But it was always the case, and it was undisputed at trial, that Dick assumed that Richard would be the one who would own and operate the family businesses when Dick no longer wanted to do that.
Why shouldn't this be a derivative suit by the corporation?
It is a derivative suit. Under 21563 of the Texas Business Organizations Code, Richard, as a sole and a closely held corporation, is entitled to bring a derivative suit as a direct action if justice warrants. And in fact, in Ritchie versus Roop, this court recognized at least twice that that is a valid means of advancing your interest as a minority shareholder. And that's what he did.
But then wouldn't the informal fiduciary relationship be irrelevant?
I'm sorry?
But then wouldn't the informal fiduciary relationship be irrelevant?
I don't think so. And if I could quote one critical line from this court's opinion in Ritchie versus Roop in pages 888 to 889. This court said, quote, absent a contractual or other legal obligation, the officer or director has no duty to conduct the corporation's business in a manner that suits an individual shareholder's interests when those interests are not aligned with the corporation and the corporation's shareholders collectively. And in the phrase, after the phrase absent a contractual or other legal obligation, this court dropped footnote 58. And footnote 58 says, quote, we have recognized that in some circumstances, a special relationship of trust may arise between parties prior to and independent from the parties' business relationship, which can give rise to informal fiduciary duties. The idea that this informal fiduciary duty claim was not properly submitted to this jury, was not properly based in Texas law, is anathema, is not accurate. This court clearly said in Ritchie that there can be circumstances in closely held corporations where there is some arrangement that gives rise to the informal fiduciary duty that we advanced at trial. We advanced that in addition to our claim that the share issuance breached the formal fiduciary duties of Dick owed to Poe Management, Inc., and we asserted that as a derivative action, but we asserted it directly because Richard was the sole shareholder, and in the interest of justice under the Texas Business Organizations Code, he alone suffered injury, and he alone had a cause of action, and as such could do so properly under Texas law. And so they are not mutually exclusive. And in fact, in this case, there was no evidence, none, of any kind of conflict between the two duties. The jury found for Richard on all fronts. And so even though the other side, the petitioners, want to try and make this notion that there is some kind of potential conflict that could exist between formal and informal fiduciary duties, there was no conflict in this case because in this case we had a single shareholder, closely held corporation. And in that context, the company, when you're operating on behalf of all shareholders collectively, which is the language out of Ritchie versus Roop, that means Richard and only Richard, meaning that there is no conflict between the formal and informal fiduciary duties that we asserted to the trial court, that we asserted to the jury, and the jury found in our favor. And submit to this court that this court does not need to address questions 1 to 3. The Court of Appeals properly decided that it did not need to decide those questions because question 4 alone demonstrated that the declaratory relief awarded by the probate judge was supportable and was sufficient and was proper. And so the notion also by Mr. Hood that this court needs to decide the informal fiduciary duty aspect of this case because it's unfair purportedly to Mr. Sargent, the lawyer, is just not accurate. As we put forth in our briefs, the Court of Appeals properly said that the jury should have decided the issue of whether or not there was a conspiracy because Mr. Sargent knew that Dick was breaching his formal fiduciary duties. On remand, we have no intention of going back in front of the jury on the informal fiduciary duty claim. The evidence is very clear that Mr. Sargent knew and conspired with Dick to breach formal fiduciary duties. And so the argument, the invitation to this court to try and decide that there is some kind of conflict between this case and what this court held 6 or 7 years ago in Ritchie versus Roop is just not accurate. And we would submit this court should affirm the Court of Appeals. It was a very well-reasoned opinion. They did not need to decide the issues associated with question 1 and question 2 and question 3. They properly decided that question 4 that may have been asked maybe a little bit better, but there was no harmful error. And to the extent that there was any error, it was invited by the petitioners because they asked for all circumstances surrounding the transaction be considered. And the reason they asked for that instruction, and let's be very clear here, they didn't have any argument on price. They didn't have any argument on the fact that the dealerships were harmed. Their argument to the jury throughout the entirety of the case was personal considerations that Dick purportedly considered. There was no evidence that Dick considered any of those things, but that was why they needed to go to the jury and with the instruction of all circumstances. They wanted to argue about alleged drug use. They wanted to argue about how Richard lost money in non-related car business dealings. They wanted to talk about Troy. They got to do all that because the judge allowed them to do that. And to be very clear.
Did you just agree that if there were a remand, you would not ask the judge to submit claims against Mr. Sargent on the basis of an informal theory?
Correct.
Informal duty theory?
Yes, and I think that's in our brief as well. If it's not clear, I'm saying definitively now that the conspiracy claim against Mr. Sargent on remand will be based solely on the formal fiduciary duty breach that he was fully aware of, and we believe the jury would have found and will find on remand that he conspired with Dick to cause that breach.
Let me ask you about a hypothetical because we, obviously write opinions for more than just this case. But what if we had a scenario where the conflict was very clear, where there was a second shareholder, and that second shareholder claimed also to be owed an informal duty? Let's say further that Dick would have discovered that Richard, for example, had been embezzling money from the entity. Clear conflict is presented. The question is,
Right.
how does your solution, your proposed solution that Dick ought to just extricate himself from the conflict, how does that actually work?
Well, I think to Justice Boyd's point is a good one in the sense that, the formal fiduciary duty, to the extent that there is any kind of conflict or any kind of issue where there would be some potential conflict, the formal fiduciary duty has to outweigh the informal fiduciary duty. And so I think that initially would address your concern. I think the other aspect to the concern here is, again, extrication is a valid way that we recognize in the law when there are conflicts to try and deal with that. We deal with that in attorney representation issues, where an attorney representing two sides has to extricate themselves if there's a conflict of interest. So I do think extrication is a valid method that should be considered. But at the end of the day, when there are multiple shareholders in a closely held corporation and there could potentially be a conflict, I think at the end of the day, Justice Boyd's point is spot on, which is the formal fiduciary duty has to outweigh and take precedence over the informal fiduciary duty.
And negate the informal?
Well, at least recognize that if there is conflict, not necessarily negate, because there may be, for example, in this situation, there may be a reason why you would give notice. You have a duty of disclosure still. But on top of that, if there was some kind of conflict as to what the action was going to be that was going to be taken by the director, it would have to be in the best interest of the company and not the individual shareholder.
Any other questions?
I see my time is up. Thank you very much. We ask the court to affirm the Court of Appeals.
Thank you, Mr. Milnet.
Thank you.
Mr. Jefferson, you have 5 minutes.
Justice Bland,
Sorry.
may I answer your question in part to counsel? With this, Richard knew that Dick always wanted to retain control over PMI. Dick took measures to make that case. He would not be able to remove Dick. Richard would not be able to remove Dick. The irrevocable proxies that Dick required Richard to sign,
those went away, though, at some point.
Yes, but after that, when those went away, the unanimous consents that kept Dick in his place as the sole director of the corporation. Richard had his own option, though. The one thing Dick could not do is preclude Richard from writing a stock purchase agreement that required Dick to provide notice of the issuance of stocks. Richard did not do that. And so Dick, in his interest of making sure the corporation would be viable and succeed, was able to issue. Remember, at the beginning of the corporation, there were 10,000 shares of stock. Richard had 1,000, so there were 9,000 remaining. And Dick, as the director, had the complete authority without notice to Richard to issue stock. And Justice Huddle, the reason that this was important is because there was a conflict. There was a clear conflict in Dick's mind at the time between any interest to Richard personally and to the corporation. There are two that are very direct. One is Dick was worried that Richard was not going to take care of his son, Troy. That's part of why PMI came together, was to take care of his disabled son. You'll hear a lot more about that in the next case. The second conflict was Dick was no longer confident that Richard could run the corporation. He did have drug problems. He did have problems in managing a business. His own separate business failed spectacularly. And so Dick was starting to think, if this is my enterprise, this is something I built over time. This is something from my grandfather, is still here in El Paso, and I want to protect it. And so he took the steps that he needed to protect the business. And the question in question 4 is whether this was fair to the corporation. Justice Busby.
How would notice to Richard have conflicted with Dick's formal fiduciary duty to the corporation?
Because Richard could have, as you just heard, tried to stop the issuance and tried to stop Dick from taking over. From the very beginning, Dick wanted to maintain control.
If that's in the governing documents, then why is that inconsistent with? I'm not sure I see the conflict.
How do you mean it's in the governing?
If he can stop it, if the governing documents allow him to stop it, then I'm not sure how that conflicts with Dick's formal fiduciary duty to the corporation.
The documents on the date that Dick issued the stock to himself did not preclude, did not require notice to Richard, did not preclude that activity at all. So the governing documents allowed the issuance without notice to Richard and for Dick to take over control.
So it seems like there's no conflict then. If Richard can't do anything with the notice, then how is it a conflict to give it to him?
The conflict arose, the conflict was the reason why the shares were issued. And there was nothing to stop it. And so the question under the safe harbor provision is whether the issuance was fair to the corporation. So the conflict, what Dick was trying to do was prevent the destruction of his company. And he did that effectively.
I ask you a question about the corporation itself. We say so many times in Ritchie versus Roop, harm is to the corporation and the shareholders collectively. Do you take that to be an equation that the corporation equals the shareholders collectively, or are they distinct things that we have to look at twice?
I think the question is to the corporation, and I think Dick's obligation was to the corporation.
What do we mean by and the shareholders collectively exactly?
Well, the shareholders are the shareholders make up the corporation. I mean, they own stock.
Are they the corporation?
Well, they are the corporation, except in terms of the management of it. The management is in the directors, and here there was only one director. And they had the shareholders.
We don't ever ask a question about harm to the management or harm to the directors. We're talking about harm to the corporation. And if the corporation equals the collective shareholders and there's only one shareholder, how does that equation apply here?
So the way I think of it is the shareholders are investors in a corporation, but there is a separate management of the corporation, and the management's purpose is to make sure that the corporation is solid and is working as it should. And here, that corporation was not just Richard. PMI had, if you look at the chart, we have a color chart in the brief on the merits. There are many different corporations and dealerships under the PMI purview. So it was not just, Dick was not just having to make sure that Richard was okay. There was an entire enterprise that had to work, including his son Troy, and that's what was in Dick's mind at the time he took over the corporation.
In an abstract sense, though, when we think about what the corporation is, aside from their management to it, maybe corporations own other corporations and other entities, is it the shareholders or not that is the corporation? So those are things that are interested in managing it and protecting it and all that stuff. The corporation is what?
Well, so I don't think the corporation is the shareholders because, just as Richie said, shareholders may have interests that are different from the corporation. Individuals.
Right.
Yes.
But what does that mean when there's only one, though?
Well, here, the one shareholder did have interests that were conflicting with the PMI enterprise, as I just
all the other
alluded
things
to. Yes.
Okay.
Yes.
Any other questions? Thank you, Mr. Jefferson. The case is submitted, and the court will take a brief recess.
All rise.